In Ferrera versus A.C. Nielsen, the court considered whether an employee handbook constitutes a contract. A.C. Nielsen, doing business as Neodata Services, issued an employee handbook in 1982 and then a revised version in 1986. The 1986 handbook expressly reserved Neodata's right to discharge an employee whose conduct warranted it. It didn't require a finding of just cause or following a progressive disciplinary procedure before firing an employee. This handbook contained a disclaimer stating that it wasn't a contract, but simply a condensation of Neodata policies and procedures. It stated that management had the right to change all policies without notice. The handbook concluded by stating that this version superseded all previous Neodata employee handbooks. Neodata gave a copy of this handbook to all current employees and had them sign a document acknowledging that they'd received it. Beverly Ferrera started working at Neodata Services in 1980. In 1985, Neodata suspended Ferrera for falsifying her time card. After she did it again in 1987, Neodata fired her. Ferrera sued A.C. Nielsen, Neodata's parent company. She claimed she'd been wrongfully discharged based on the employee handbook, which she argued was a contract limiting Neodata's right to discharge employees. Ferrera also argued that the 1982 handbook, which had no disclaimer, should apply to her situation. The trial court held that the 1986 employment handbook couldn't constitute a contract because of its disclaimer. It granted summary judgment to Nielsen. Ferrera appealed to the Colorado Court of Appeals.